My name is Jim Simpson, yeah, we're going to talk about search and seizure. What I hope to accomplish today, first of all, we've got a short period of time, okay? We've got about 60 minutes, and I hope to give you sort of a general overview of search and seizure law as it applies to schools. And it's a huge topic, and I'm going to move fairly quickly and try to cover as much as I can. But at the end of the day, I think that you'll be able to come away with a few different things. First of all, I hope that you'll be able to come away with enough of an understanding of the search and seizure Fourth Amendment law as it applies to school districts that you'll be able to answer general questions coming from your clients. Second of all, I hope that you'll have enough information that you'll be able to advise the districts with respect to sort of preemptive things that they can do as a district to help lessen the scope and the impact of the Fourth Amendment and hopefully make their schools a little safer. Finally, I really hope that you'll be left with some general approaches of how to teach this a little bit to districts and how to instruct on this. Because the reality is, if you're getting a phone call about a Fourth Amendment question or a search and seizure question, there's a really good chance it's too late. And I think that you will find that when you offer the instruction to districts, that they are hungry for it, and they are very gracious when they get it, particularly those in the district that might find themselves in a search and seizure type situation. So of course, for me to do any of that stuff, you have to have a general understanding of Fourth Amendment law and how it applies to schools. And so we'll jump right into that, and we begin with this statement. The Fourth Amendment prevents the government from unreasonably intruding into people's legitimate expectations of privacy. And more or less, that's the scope of what we're going to talk about today. And you can break that down, of course, into three different elements. And I like to have districts or the students that I instruct on this use it as kind of a checklist, all right? When you're dealing with a Fourth Amendment problem, you can take a look at this. You can go, okay, is it a government actor? Do we have a government actor? If we do, was there a legitimate expectation of privacy at place? And if there was the intrusion into that by the government actor reasonable? Right? And if those questions, if none of those or any single one of those is not satisfied, well, you don't have a Fourth Amendment problem. And so that's the way I've sort of organized the course, is to look into those. Now, obviously, when I teach the course, I do it in the scope of a half a day to a day, not in 60 minutes. But nonetheless, I think that we can accomplish things. So we'll look at government and how that applies to districts and when they are or not government actors. And we'll look at expectations of privacy. Students certainly have it when they walk in the school gates, but it's reduced to a significant extent. And so we'll look at to what extent it is reduced and things that you can do as a district or in advising your districts to lessen that expectation of privacy and therefore the applicability of Fourth Amendment search and seizure law, right? So we'll look at exceptions to that, obviously, and we'll look at the principles of plain view, abandonment, and consent, items which I think you probably are familiar with on some level, but we'll look at sort of the implications of those and ways that we can take advantage of them as an investigator or as a district, right? And then obviously, if we've gotten to this point where we've got a government actor and there is an intrusion into an expectation of privacy, we have to ask ourselves whether or not that intrusion was reasonable. And we'll find that whether or not an intrusion or a search is reasonable depends on a couple of things. First of all, to be reasonable, the search has got to be justified at inception. And all that means is that there are reasonable grounds for believing that the search will turn up evidence of a school rule violation or a violation of the law, right? It's not a hunch, it's not a guess. There are objectively reasonable grounds for suspecting that. So it's got to be justified at inception, and it also has to be permissible in scope. Now, to be permissible in scope, you'll learn that, first of all, the measures adopted for conducting the search, the method by which you undertake the search, has to be reasonably related to the objective, right? So if we have a suspicion that the student is in possession of a stolen hard drive, we don't get to do a blood draw, right? If we have a suspicion that the student is in possession of a stolen bicycle, we don't get to look in the backpack, right? Because a bike couldn't fit in there. All right. So the measures adopted have to be reasonably related to the objectives, and they can't be excessively intrusive in light of the age, sex of the student, in the nature of the infraction, which is something that plays a big role. okay? So we're going to dive into those things. And it's helpful to start off with taking a look at what a search is, right? And a search is an intrusion, however brief or cursory, into a protected privacy interest. That's what it is. And some examples that are not exactly intuitive, particularly for a lot of district administrators and teachers, are things like pat-downs, directing a student to empty their pockets, which you see all the time and is a great starting place for a search. Reading material in a student's diary, reviewing or downloading cell phone or computer data. We'll talk about some state law that constrains that towards the end. Video or audio surveillance, which almost all districts engage in, but of course the question is not just whether it's a search, it's whether it's constitutional. And whether it's constitutional will depend on the things that we're going to talk about, particularly whether or not there's an expectation of privacy at stake. Are we surveilling a school bus, or are we surveilling the locker room, right? Tracking devices, which I put in there because ordinarily tracking devices involve putting a magnetic device underneath the target's car. But in the age of technology and iPhones and things like that, Find My iPhone, it wasn't unreasonable for me to see this situation arising. And so I think it's helpful to know that it includes that type of technology. Taking a DNA sample with a buccal swab from the mouth probably is something that's going to happen most frequently from law enforcement, hopefully not district administrators. But I throw that in there because you do have to be cautious of W&I 625.4, which places severe limitations on the ability to collect DNA samples from minors. And then drug tests, which we see in the case law occasionally with respect to athletes and then some schools where there's a serious safety concern or risk. Okay, so let's look at government and just sort of jumping right into this, just sort of a little historical perspective and something that I really try to emphasize and point out and remind the students in the districts is that the Constitution, right, is a restriction on government, or at least that's the way it was designed, right? You had the colonists back in the 1750s there, and the Brits are running the show, right? And they've got these writs of assistance that allow their basically enforcers to search anything, anytime, for any reason. And so they're in the houses, in the private areas, the persons of the colonists. And as you can imagine, the colonists didn't like that very much. So when it became their time to run the show, they put restrictions on that, and restrictions on what the government is able to do, okay? And I stress that not only to point out that, but also because it's going to be important to point out the dichotomy between the principles of Fourth Amendment law and California statutory law, which we have to get into. We have to talk about it because it interplays in complex ways, right? These are some cases which are interesting to read. Webb is an interesting case. It's public school situation. You had a female high schooler. She was away with the school for a band competition, right? And I think it was in Hawaii, right? So the students got their own hotel rooms. The chaperone got wind during that time that Miss Webb had some form of contraband or misdoings in her room, went up, conducted a search, found the contraband, which in this case was, of course, boys in the room, right? You weren't allowed to have boys in the room. And I don't think the contraband could not be seized. I think the contraband in this case actually leapt over the balcony and might have landed in some bushes, I think, if I'm recalling correctly. In any event, it's a fun case because it's far removed from the school district, and the court spent some time talking about that, as well as a principle of in loco parentis, which almost never applies, but it applies here in a way that gives school personnel a little broader range of control. So check that case out. Ruiz and Considine are both private school cases. Ruiz is a search of a substitute teacher who is using a cell phone to take pictures underneath the skirts of his students, and principal seizes the phone, looks at it, calls the police. Mr. Ruiz tries to claim a hearing. No, you got to suppress that. My Fourth Amendment rights were violated. And the court said, nah, not really, you're private school. So sorry, doesn't apply. And then similar with Considine, that was another private school in Massachusetts, kids on a field trip kind of like Webb, they had their own hotel room. Search led, reasonable suspicion led to a search of the room and found nefarious items. Students tried to suppress, and the court said, "You're private school kids. We don't care. We care, but the Fourth Amendment doesn't care." So, in any event, okay. So expectations of privacy, right? And this is an area that, if understood and applied correctly, can give districts a lot of latitude in how they can affect the implications of the Fourth Amendment, right? And students, certainly they have an expectation of privacy, but it's not unlimited. We've got our exceptions, right? There's no expectation of privacy in items that are in plain view, items that are abandoned or consensually relinquished. And so when I'm teaching this, I like to take those sort of one at a time to draw out sort of the implications of things that seem on their face very obvious, like the plain view doctrine, okay? So with respect to the plain view doctrine, obviously we got the general principle there, right? So school officials can observe and detect anything that's open to their senses, right? Sight, smell, whatever, provided they've got a legitimate reason for being there, and they haven't used extraordinary means to get there, right? We don't have infrared goggles or things like that, right? So the way that I do this, in Ray Cody is a case that this sort of describes this principle, but the way that I do this with the students, and I do an exercise with them that I'm going to kind of run through with you now. And I do it kind of at the end of the class after they've gotten, a full breadth of the expectation of privacy principles, the, unreasonable intrusions, justified at inception, permissible in scope, those types of things. And I do it to sort of impress upon them the significance of the plain view doctrine and reinforce some of the other components, okay? And this is how it goes. So I start off with a container, right? A backpack, a knapsack, this exact one, right? And the game goes like this, right? Find all of the contraband that's in this knapsack and do it legally, right? According to the Fourth Amendment. Now, I force them to start off by questioning me in order to generate an initial reasonable suspicion, but I'll cut right to the chase with that with you. And we'll just say hypothetically that we've got a student and we have reasonable suspicion to believe the student is in possession of a stolen textbook, okay? Like a big one, we'll say like a trigonometry textbook or something, right? Go, right, is the mission for the students, right? And by this point, I've told them about, the unreasonable intrusions and how it has to be justified at inception and permissible in scope, and they know that the search, the manner in which it's conducted, has to be related to the objectives of the search, all right? So they know that they can't search for a stolen textbook in here, right? Because it wouldn't contain it, this too small, right? So and if they start there, they fail, right? They fail, right? So they have to start in a place, where they're looking for that item, so where that item could reasonably be. And they look in here, and guess what? There's no trigonometry textbook in there. But what they do find is a weapon, okay, a firearm in this particular case. And the beauty of the plain view doctrine, right, is that it allows us not only to seize this, even though that's not at all what I was looking for, right? I can seize it and I can use it as evidence, but I can now use that to bolster a reasonable suspicion that there might be other things, maybe smaller things, in other compartments, right? In this particular case, it would support a reasonable suspicion that the student or this backpack might contain other weapons, right? And so while that doesn't get me into smaller compartments here, I can come back in the front here, right? And I can look in items where a weapon might be, right? And when I do that and I open up this compartment, guess what? There's no weapon in there. And there's obviously no trigonometry textbook in there. But what is in there are a pay and owe sheet, right? And if you don't know, a pay and owe sheet is just a list of debts, credits, assets used by narcotics traffickers to keep track of who owes them what and what they provided, right? There's a gram scale, right? And there's these tiny little sort of baggies, right? One of which contains a white crystalline powdery residue, right? And so what can I do with that? Well, I can seize that and I can use it, and I can also use it now to bolster suspicion that there might be other evidence related to narcotics trafficking. And so now I can come in here and I can go into these smaller compartments, right? And I can pull out, what is actually an 8-ball of sweet and low, right? But, an 8-ball, just, narcotics, right? And the exercise goes on like that. There's a lot of other sort of items that I put in here to sort of draw it out and everything and make some other points. But you get the idea. The point being is that none of that would be possible, right, without the plain view doctrine, right? And so we not only emphasize that and the, the utility of that, but we also stress, the principles of, your measures have to be reasonably related to the objectives. You can only look at certain items, as well as bolstering, the types of things that will support a reasonable suspicion, which at the point that I do this exercise would already have been, covered with the students. Items that are abandoned. It's another sort of principle that I think seems commonsensical, but has some very profound implications. Okay? Obviously, there's no expectation in items that are abandoned or discarded. And abandonment can be reasonably inferred when a student throws an item away while in flight by a school official who has a lawful purpose for pursuing and approaching the student. So, for example, a student is running away from a school official who has a lawful purpose, for approaching, and during the course of the chase, student, discards their backpack. Well, when they discard their backpack, they're also disregarding, their expectation of privacy in that item and their Fourth Amendment, protection over it. And so that entire item now becomes subject to search. Intentionally leaves or hides an item in a public place. I want to talk about that in a little more detail, along with disclaiming ownership, okay? So intentionally leaves or hides an item in a public place. RM versus state is a situation where student is in classroom, he's got a backpack, and he asks the teacher if she can sort of keep it for him behind, I don't know, a dresser or something like that. Now, the teacher in that case was a little bit suspicious, but was willing to go along with it because she knew that the student had a medical device that he used periodically, and assumed that that's the reason that he was, having her keep it. Well, student leaves and doesn't come back, and is gone for such a time that the teacher knows that by that point, the student would have needed that device. And so her suspicion goes sort of way through the roof. She calls in the school resource officer, who conducts a search and finds a weapon, a handgun in there, and the court, looks at that and finds the search to be sufficient based on a couple of principles. First of all, the abandonment, and then second of all, that there was sufficient suspicion. State versus Polk is a good case as well. It deals with leaving a backpack on a bus, and some school policies that also help to lower the expectation of privacy that we'll get into. So, disclaiming ownership or disassociation. So this is a situation, or I find that individuals, whether they're students or not, who have something to hide or know that they've done something wrong, have a tendency to outsmart themselves sometimes. And this principle, if used correctly, I think allows us to take advantage of that in certain situations. So, for example, when you're dealing with a student, you're getting ready to interview them, it may, depending on the circumstances, behoove you to provide the student with an opportunity for disassociation, okay? So, for example, whose backpack is this? Is a standard sort of investigatory question, right? Now, you don't want to ask that question if you've got concerns with identity, right? With linking the backpack or the container with the student, right? You wouldn't want to lead them into that. But assuming that you can establish that pretty firmly, whose backpack is this? Is it, or whose whatever it is a good standard investigatory question, and it may very well provoke a response such as, I have no idea, or it's not mine, or something like that, which would be a disassociation, a form of disassociation, and enabling you to investigate further, search the item, so on and so forth. So a couple of things with that. The language there I chose specifically because California courts in particular, when they're dealing with this, have kind of backtracked a little bit in the last 20 or so years. It used to be that you could get away with a question like, is this your backpack, followed by a negative response, and that would do it for you. And sometimes it still will. But lately, courts have been taking the approach when faced with a situation like that, where the question is something akin to, is this your backpack? And student's response is no. And then student later, in his defense argues, well, it wasn't my backpack, it was, my brother's, and I was borrowing it from him. So I selected this phrase as preferable, I think, because it helps prevent that kind of argument later on, okay? That kind of permissive use argument, right? So if you ask them, whose backpack is this, and the student says, I have no idea, it's obviously more difficult for them to come back later on and suggest that it was, their brother's or something to that effect. So consent is going to be your go-to most of the time, right? Obviously, if you can receive consent from a student, then the Fourth Amendment doesn't apply. And so it's really hard for me to envision too many situations where you wouldn't try at some point to get consent from the student. And what I try to impress upon the students when I teach this is that there's no formality required, okay, either in the seeking of the request or in the giving of the request, okay. So in terms of giving the request, the advice I give is that actually the less formal, the better, okay. Far better to do it in a casual setting. Maybe you're walking up to the administrative office and you ask the student casually, would you mind if I, when we got there, would you mind if I took a look inside your backpack or something like that? Far better to do that than once you get there and student is sitting down and maybe they're surrounded by administrators, right, and they're in the hot seat, okay? Far better to do it the first way for two reasons, right? So first of all, if you do it in a more casual environment, then the student, may very well be more amenable to consenting to the search, right? And without the formality of the situation. And second of all, doing it in a less formal environment improves the chances that it will be upheld when that search is challenged or when the consent is challenged for reasons that we're going to get into in just a second. All right. So declarations of consent can be given expressly or impliedly. Okay. Again, there's no formality required here, right? So, for example, if I ask the student for consent and they tell me yeah, yes, fine, anything like that is going to be is going to pass muster, provided that it's sufficient to cause a reasonable person to believe that the student had consented. Okay. Expressions of indifference will are upheld as well. Okay. So, for example, the request for consent comes and the response is whatever, that's going to, based on the current case law, that's, that it would be sufficient to cause a reasonable person to believe that the student had consented or at least was indifferent to the search. And then at the same time, consent can be implied as well, okay? If you ask a student for permission to search and the student, says nothing, but, hands over their backpack, you've got consent, okay? And then obviously there's some important caveats, right? Consent is not voluntary if the student is acquiescing to a show of authority. That's the second reason why I feel like the less formal, the better, right? Because if the student is sitting in the administrative office, like I said, with the pressure on, surrounded by, administrators, surrounded by a show of authority, it's going to be, it's not going to invalidate consent automatically, but it's going to be a factor to consider. And I think courts tend to look much more favorably on a situation where it was a casual environment, there was no pressure, and courts are much more likely to find that the consent given was in fact voluntary. So it's got to be informed and voluntary. The informed part, I don't want there to be a mistake there. It doesn't mean that you have to tell the student that they have the right not to consent. You definitely don't have to tell them that, and I wouldn't advise doing that. But what informed means is that the student has to understand exactly what they're consenting to. Right? They have to understand the scope of the consent, and to the extent that an individual, an administrator, or a law enforcement officer goes outside of that, then the search is going to be suppressed. Age is a factor here, right? Almost always with school children, right? Because you have to look at, if the student is young enough, really young, or is a student with exceptional needs, you may run into problems where the student lacks capacity to give consent. And so for that reason, my recommendation is that regardless of the age of the student, okay, whether they're 4 or they're 18, always make documentation, always produce documentation regarding their capacity, okay? I talked to students seemed lucid, understood my questions, was able to follow directions, knew where he was, those types of things, particularly if you're dealing with a student who's intoxicated. Those questions are really important, right? Because the consent has got to be informed and voluntary. And so establishing that and making a note of it in the report is obviously important. So just some examples, right? Students consent to search after it was expressed or implied that the search would be conducted with or without his consent is involuntary. It cracks. How many movies are there out there, where the cops show up at the door and they go, you're going to let us search, or we have to go get a warrant, right? Totally invalid. Totally invalid, the consent. You just invalidate the consent by doing that, okay? By putting them in that position. So definitely, don't ever do that. We'll look at one case where that happens. Fortunately, it didn't matter because there were other bases for the search, but just, so don't do that. Here's a question, you don't have anything in your pockets you don't want me to see, do you? Negative response, then you wouldn't mind me looking, would you? That's questionable. The case that I cite there is not a school case, and it deals with a lot of other issues, but I put it there because the court really focuses on the voluntariness of the consent related to those statements. I would stay away from that stuff, or I would advise your districts to stay away from that type of verbiage. Again, informed and voluntary, right? Surveillance, we had mentioned that earlier as being a type of search, and I mentioned it's a two-part question, right? Is it a search first of all, and is it constitutional and legal? Obviously, as I said, most schools have surveillance cameras throughout their district and on school buses and things like that. And by now, and the students usually know by now, that that's going to be okay, right? Why? Because, a reasonable person or society would not expect that to be, they wouldn't have an expectation of privacy there, right? And they assume walking down the halls, they're aware of the cameras, they can see it, so the expectation of privacy is reduced. Obviously, if we change the situation a little bit, we start putting surveillance cameras in bathrooms, or locker rooms, that changes quite a bit. And that happens more often than you would think. It happened a few years ago in 2008 in this case that resulted in, there are about 20 times in reading that case that you'll really start scratching your head. But just sort of a brief factual background, you had a school assistant principal who decided to put, they had some theft issues, I guess. So decided it would be a good idea to install cameras in the boys and girls locker room of a middle school. He did this in collaboration with the in collaboration with the principal. So we had the assistant principal and the principal. After they install the videos, of course, after they install the cameras, the assistant principal notices that, hey, when you're looking through these, right, you can actually see the students, the female students, disrobing, right, taking their clothes off, things like that, and brings that to the attention of the principal and to the effect of, hey, maybe we should move these. And the principal, upon hearing this, agrees 100% we should definitely take these out, but they never do. And so what happens next is, well, what you might expect. A few weeks later, the school is hosting a middle school females basketball tournament. And the other visiting team comes over, they're using the locker room, and one of the students remarks to their coach, why are there cameras, looking at us while we're changing? Next thing you know, you got a class action lawsuit by 34 female middle school students from the visiting team that succeeds. It gets worse after that. It's just, you read the case, but the cameras were not closed circuit, so you could access them outside of the school district, and there was supposed to be a password on there, but they never changed the default, and so they had access logs from all over the country. Huge, it's just bad. Anyway, don't put cameras in locker rooms, right? But I spend time on that just obviously to point out, the differences in expectations of privacy, right? So what can we do to sort of lower the expectations of privacy of the students and then lessen the scope and the impact of the Fourth Amendment search and seizure law? Well, here's one way. So first of all, we've got the vehicle code section down there, which is 211.13. But to begin with, I like to ignore that completely and just talk about the effect that this sign has on what we're discussing, okay? We've got big bold letters, right? All vehicles are subject to search. And then it goes into a good bit of detail below about that, by entering, this, any person, whatever. You consent to search and we can do it, regardless of the circumstances, right? Now, I just want you to appreciate the effect that this has, right? What does it do to the expectation of privacy, right? It lowers it right down. And so we can do the same types of things with the policies that we implement with respect to, backpacks left on buses, field trips. I'll give you a bunch of examples in a second. But for the, I don't know whether this would cause a search to be upheld by itself, but it's going to get real close. And it's not unreasonable at all for me to see a court looking at this and saying, you know what, this student had no expectation of privacy, right? We had it in big. If I had it my way, I think I'd have dancing inflatable tube men, right? With search signs on either, buffering the thing, we're going to search your, I don't know. But you get the point. It stresses, it reduces the expectation of privacy, okay? Because of the manner that it's posted. Now, 211.13, basically, I'll sum it up for you. It basically says, first of all, with respect to educational institutions and a lot of other facilities, you cannot drive, park, ride your horse through, do any of those things, okay? Unless you have the permission of the district, okay, of the school board. And when the school board announces their permissions, all right, the scope, the situations in which individuals can use vehicles in those areas, they can apply whatever condition they want, okay? It really is that broad, like whatever condition they want, provided that that condition is posted on a sign like it is here, and then there's a copy of it where individuals can access it easily, okay? And so I want to point that out, but I need to back up a second and just remember the dichotomy that we have between the state and the federal law here, because it's very easy, particularly for administrators or schools, to look at this statute and say, well, whatever condition, we're golden, we can do whatever we want. But you have to step back and remember, well, it may get you past some state law things, but it's not going to get you past the Fourth Amendment, which is a federal law. They're still going to have to do that analysis. Do we have a government act, or was there a reasonable expectation of privacy, and was it unreasonably intrusive? But the upswing, of course, is that when they're doing that middle question, is there an expectation of privacy? This is going to weigh really, really heavily. And so, again, I just sort of try to stress that distinction to students and administrators when teaching this. Okay. So I said I would give you some examples of policies that are, that have been upheld. Parking lots, lockers, school buses. Okay, we talked about an example of that already. Unattended items, right? These are just situations where school policies, would be helpful. Field trips. It's a great case on field trips. Basically, it was, I believe, a middle schooler, and school had some trouble with field trips because the students were bringing contraband. And so as a result, they put in place, this policy that said, before getting on the bus, your items are subject to search. And they highlighted the various reasons for that. And most importantly, they sent it to the parent and the student, and they required a signature on that beforehand, right? That's a critical component, obviously, okay? Because, it's only going to lower the expectation of privacy if they're made aware of it, and you can, show that. And so in that situation, the court, when a search was conducted based on that, the court said that was fine, even though there wasn't necessarily individualized suspicion. It was closer on what we call an administrative search, which is a huge area that I just don't have time to get into. But the court said that was fine in that particular search situation because of the need, because it was distributed to student. We had the signature on there, and importantly as well, the fact that not only does it lower the expectation of privacy, but it protects the student in a little bit, okay, in a certain sense. So if they've got an item that is, sensitive, it's not illicit, but they don't want it disclosed, well, they're on notice now that it's going to be searched. So they can put that item somewhere else or not take it with them on the field trip. So some examples, policies there. Campus reentry in Ray Shawnee is a California case. That's a great case. It's a case where, if I recall correctly, the district didn't actually even really specify a special need. They just had a blanket policy that, look, if you're a student on campus and you leave during the day and you come back, you're subject to search. They articulated general reasons, the safety of the environment, things like that, the possibility of bringing on campus illicit materials. And student came back and was asked to empty his pockets, and he did, and there was narcotics found, and the court said that was fine in that particular situation. A couple of points about that and really administrative searches in general is it has to be uniformly applied, and I know that in Ray Shawnee, the court made a big point of that, that the principal who did the search did this every time every time this happened, it was uniformly applied, there was no disparity, which is critical anytime you're in a situation that may lack individualized suspicion and bordering on sort of an administrative search. Okay, so unreasonable intrusions. So if we've gotten to this point, right, we've got a government actor, right, and we've got an expectation of privacy, and presumably we have an intrusion, okay, or a search into that privacy expectation, all right? So there's no consent, there's no abandonment, things are not in plain view. You've got a student, and he is saying, no, you do not have permission to search, does not want you to search, and you're a government actor. Is it constitutional? Of course it depends, right? What does it depend on? Well, it depends on whether or not the nature of that intrusion or that search was reasonable, right? And what does that mean? What does it mean to be reasonable? Well, as I sort of mentioned at the beginning, right, to be reasonable, for the search to be reasonable requires two things, right? It's got to be justified at inception and permissible in scope. To be justified at inception, there have to be reasonable grounds for suspecting that the search will turn up evidence that the student is either violating a school rule or violating the law, right? To be justified at inception. It can't be based on a hunch, it has to be, reasonable, objective, right? But it also has to be permissible in scope. And to be permissible in scope, right, it's got to be, the measures adopted have to be reasonably related to the objectives, and it can't be overly intrusive in light of the age of the student, their sex, and the nature of the infraction, okay? And so we've talked about that a good bit in some of the other examples, okay? Those are the definitions there. But looking more closely, so this is just the diagram I use with the students, just to get them to understand the separation between justified at inception and permissible in scope, okay? One way to define that is, the motive and the method. Motive isn't the best word there. It kind of works. It's alliterative, so maybe they'll remember it more, but it's just sort of a way that I demonstrate for them, those two, that dichotomy, right? So if we take a look at unreasonable intrusions, right? Was the search justified at inception? We've got our general definition there. And then, as I mentioned just a second ago, this is an objective standard, okay? And this is an important point that I really want to sort of emphasize, this objective standard. Because I think that more often than not, when instruction is given on this portion related to searches being justified at inception, I believe oftentimes it's taught the wrong way, okay? And it's taught, if it's taught by an attorney, it's taught the way that we were taught in law school, okay, by giving case examples, okay? That is, here are a number of situations where the courts have found there was sufficient reasonable suspicion, okay? And I'll go through these. I'll give some case examples, okay? But flight from specific activity, intoxication, proximity to offense, information from informants, both known and unknown, okay? And so we have a tendency to teach it in that way by giving a list of examples where there is reasonable suspicion, where the courts have found that, okay? And it's problematic for this reason, okay? First of all, if we just step back and we take a look at cases or situations where we end up failing in here, okay? Where we end up conducting a search and it's found, not to be reasonable, not to be justified at inception. What I think that you will find is that the vast majority of cases where we get burned on this issue, where we fail, involve a situation where you've got a reasonable teacher or administrator, all right, level-headed, very reasonable, who has a legitimate, good faith, subjective belief that the search of this student in this particular way will turn up evidence of suspected wrongdoing. Okay, but we nonetheless fail, and it's the vast majority of cases when we fail. It's that situation. Okay, a legitimate, reasonable teacher administrator with a good faith belief. We fail not because of the situation that we're teaching, right? Not because it wasn't intoxication, it wasn't flight, it was something else. Not because of that. We fail because of the inability to articulate that, okay? We fail because in reality, it's very difficult to take all of the inferences that our brains take in automatically. I'll draw the inferences that we draw automatically from a situation if we're not trained to do it or if we're not preparing to do it, and put those down on paper, not to mention a situation where you've observed an encounter that has given you a subjective reason, a subjective belief, and then you're asked to articulate it years later and you haven't taken good notes. Okay. To illustrate for the students, I do an exercise with them, okay? And what I do is I divide the class up into two. And with the first half of the class, I show them this picture, okay? Or there's a number of pictures I use, okay? This is kind of a middle of the road picture, right? I show it to them, for a few seconds. I have them take a look, take it in. And then I take it away and I ask them, is it reasonable for an individual to have a suspicion that a crime is taking place? Okay, is it reasonable for an individual to have a suspicion that a crime is occurring here, right? And almost universally, the answer is yes, okay? But then what I do is I have the first half of the class articulate their reasons to the second half of the class that has not seen that picture. And I remind them that they can't use conclusory language, okay? They can't, well, she was looting or she was, stealing. You can't use conclusory information, okay? I mean, in a real-world setting, you could use conclusory information in your report, but you're going to be asked to back that up later on. What makes you say they were looting, right? And then I sit back and I watch them struggle with this. As the second half of the class, again, I do this kind of towards the end, tries to judge based on what they're telling me, with no knowledge of the picture or anything like that, whether or not it rises to the level of reasonable suspicion. And I watch them struggle with that. But the good news is that when you do that, okay, when you put that in front of them, it presents to them the real challenge, right? Which is, first of all, making a note, because, if you think to yourselves, right, you probably knew where I was going when I showed you the picture, but if you sit down now and you try to articulate that for yourself, you'll find that there might be some challenges. Maybe you get all the things that are in here. You look at the fact that the windows are broken out, that she's got, seems to have some sort of bulge in her pocket right there, right? That there's an individual behind her who's not wearing a mask but seems to be trying to conceal his identity, that she's carrying a whole boatload of, similar items that she's running, which many of which are all typical of a Black Friday sale. But you've got, individuals next to her which seem to have a lot of the same items, and like I said, the windows are busted out, those things. You might have gotten all of those things, okay? But imagine that you're an investigator doing this, right, who hasn't been trained in this, right, or a school administrator or a teacher, and you write in your report, just for example, student was looting, right, and then a year and a half later, you're on the witness stand, and they're asking you, what makes you say that they were looting? Good luck, right? Good luck, But if you're trained to do that, if you know that you're going to need to do that, then the tendency is more, like I said, the inferences for the most part here are going to be subconscious. But if you're trained, if you're expecting it, that when you encounter a situation like this, you're more likely to consciously go through and make a mental note, okay, these are the things, because I'm going to have to put that in a report and I'm going to have to justify my suspicions, okay? Okay, so I said I would go through some examples, and I do, and I'm going to, and I do this with the students, but what I want you to know is that when I go through the case examples here, my stress is not on the circumstance. My stress is on how it was articulated, right? And so I pulled some cases that are, helpful in that regard. This particular case involves flight suspicious activity, and basically the school administrator, or actually I think it was a resource officer or something like that, saw these kids on video camera. Two of them were standing outside the bathroom, boys and girls bathroom. He paints a nice picture, like as if they're acting as lookouts, right? And then he and his partner come down to the bathroom, and as soon as they get there, one of the students is walking out of the bathroom, takes one look at him, turns around and bolts back in the bathroom. And he follows and sees the student stuffing something in his waistband, conducts a pat-down search and then a more extensive search, turning up the evidence, okay? But he does a decent job of articulating, at least a decent enough job for the courts, okay? So intoxication is an example that I use in that exercise that I just did, okay? So I show him a video of an intoxicated individual, and see, try articulating that. It's difficult if you're not prepared for it. Anyway, this is a good case on intoxication that helps demonstrate that point, right? So freshman English teacher, right, saw a student acting very, really, really different, okay? She observed student for 3 to 5 minutes standing at his locker, talking to friends. That's good. Student's behavior caused teacher to think student was either ill or under the influence of something. That seems a little bit conclusory, but courts will let you get away with that because just as long as it's presented by the attorney in the right way, that it's an expression of sort of their mental thought process, right? Student appeared to be quieter than normal, and student's eyes were basically shut. Teacher was familiar with the student, and student was normally open-eyed. This is the really critical point for me, okay? And it's something that really needs to be done in these types of investigations, and that is familiarity with the student, right? Because without that, that doesn't really work, right? If you have no basis for comparison, well, who's to say that they're, maybe that's just the way they are, okay? But an articulation of the fact that, look, I've worked with this student, I know this student, their behavior was abnormal. On the same token, if you've got a situation, like flight, it's counterintuitive if you've practiced criminal law, particularly criminal defense, but you could look at their history of discipline, right? And so if you're in a situation where you have time to think about, right, how you're going to approach the search of this student, you can look up their discipline record, and if it's this suspected activity involves narcotics and they've got a history of, possessing narcotics, well, that's going to elevate your reasonable suspicion, and that's absolutely okay. Just make sure you make a note of it. You document it, right? It's a legitimate reason, so take the time to look into it if you don't know it naturally. And then along those same lines, it is always appropriate to talk about your experience, things that you've viewed, things that elevate your reasonable suspicion. Because remember, it's an objective standard, but it's not, the reasonable person standard is a reasonable person standing in your shoes with your knowledge and expertise, generally. Okay? So it's important to articulate that, right? And so, yeah, so student was not acting normally, concerned about their welfare. Proximity to the offense, I thought this was a tough case where they did a decent job of articulating basically students in detention, right? And student has to go to the bathroom, student takes off. Next thing you know, third floor fire in the bathroom. Teacher runs up there, sees student walking quickly past her, pulling his hood over, sort of, trying to shield his view, makes eye contact briefly and then takes off. Does a decent job of articulating it, at least a good enough job, right? I mean, all of these cases are sort of on the line. And then there's some dialogue, student says they didn't do it. You have no right to search me, right? Teacher, if you don't consent, I'll call the police to do it by force. Well, this search might be legitimate, but it won't be because the student consented, right? That's like, you've destroyed that at this point, okay? So probably should not have said that, but it's okay because the court, found that there was reasonable suspicion to conduct the search based on the, the conduct that was described by the teacher in that particular situation. And so they does a search, doesn't find evidence of the fire, but finds other evidence of narcotics trafficking, conducts a further search. Anyway, it's another example kind of like RM versus state, I think, that I talked about earlier. Okay, so observations, In re Lisa G, I talked about this. So this is a good case to talk about with students. So students being disruptive in class, and she's just, read the case. All the cases I selected that are in your packet, by the way, I really tried to find cases that were short, so you're not combing through like a 100-page death penalty case, right? This is a short case, and it's a California case, not too old. Basically, student is being really difficult, really disruptive in class. I need to go to the bathroom. She goes to the bathroom. She comes back. I need to go out again. Just being disruptive. And teacher says, no, you're not going out again. You need to stay put and learn. Student keeps doing that. Finally, teacher gets fed up and just says, go, just go. Well, student leaves and the door locks behind her, and I'm not really sure how that happens. Student comes back, can't get in, sits in the hallway. Class ends. Student had left her purse behind. Teacher conducts a search of that purse. Why? Conducts a search because she wants to write the student up for discipline and is looking for identifying information, the student's ID number, something like that, right? And then goes in and finds, I forget, narcotics or weapons, something she's not supposed to have. And the court said, sorry, that search is suppressed, right? Because there's no, yeah, I get it, right? You're looking for identifying information, but that's not a legitimate reason that doesn't get you past the Fourth Amendment requires. You got to have reasonable suspicion that the search is going to turn up evidence that the student was, violating a school rule or a crime, and that's not going to do it. So, yeah, just sort of a good counterexample. Informants, right? So when we move to informants, right, before we're talking about articulating the nature of what we observe, which is difficult as it is. With informants, I don't know, maybe it's a little bit easier, but you have to undergo the same thing. So with informants, we haven't seen the activity that is, justifying our search, but we hear it from somebody else. So now what we have to do is articulate the credibility of that informant. If it's a known informant, whether it's a student or it's a parent or whatever, credibility can come in the form of if you've got interactions with the student, right? The student has always been honest with me, has never lied, has got good grades, whatever. Things like that bolster their credibility, okay? And you're also going to be looking at things that they describe about what they saw that lend themselves to, credible situations, okay? This is another sort of good teaching example, GC versus state, right? So basically, you've got a group of students, 8 students, and they tell a teacher that, I saw a student with a taser, and you've got 2 individuals in that group, okay, who say that I saw the target, the student, this particular student, with the taser, right? We're dealing with informants. We're good on credibility here because we've got corroboration. We've got 2 individual people in that group saying the same thing. So student comes back, it was late at night, so student comes back to school the next day, she's got a purse. Teacher searches that purse, goes and looks in the purse, doesn't find anything. Is that search okay? Yeah, the court said that. Said, look, you're fine there. You've got reasonable suspicion. You've got a heightened, we need to keep the school safe, and a taser is a dangerous weapon. You're good there, right? But what happens after that is problematic. So what happens after that is the teacher goes to the principal and tells the principal, the set of circumstances, and the principal asks the student to come in. And when the student comes in, the principal notices that there's a bulge in the student's purse, right? And then conducts, a search, and what's in there? The taser, right? Well, the court suppressed that. And first of all, for reasons that you might imagine, and that is, obviously, if I've searched the purse already one time already, and there was nothing in there, what does that do to the reasonableness of my suspicion? Well, it's going to lower it, right? So I'm going to have less of it's less likely that the court is going to find that your suspicions were reasonable after that, right? Particularly since the principal was aware that the search had already been conducted. Now, does that mean that you can't ever do a second search? No, absolutely. In fact, I want to talk about how this search would have been perhaps salvageable, okay? But the fact of the matter is you're going to have something more. And all we get out of this case is a bulge in the purse. And the court says, sorry, that's not enough. Now, what they could have done, and I obviously don't know all the details behind the case, but the principal could have seen the bulge, and done some more investigation. Ask the student, hey, what is that? And look for a reaction. Does student react to that way? You know, do they start looking nervous? Are they, you know? All of these things will serve to sort of bolster your reasonable suspicion, you know? Obviously, maybe ask for consent. Would you mind taking that out? You know, what is that item? If they struggle to come up with an answer, if they make up something unbelievable, that's going to heighten your reasonable suspicion. All things that you could do that might have salvaged this search, okay? These are some general principles the courts like to see when you've got anonymous tips. If you've got some of these factors, I won't go through them. You can sort of read them on your own. They're going to bolster the credibility of your anonymous informant, right? So this is another good training example. It's an unpublished case, but it's the law and the reasoning is fine. And basically, it's just a situation involving graffiti. Principal, I think, maybe gets an anonymous phone call from someone who says things that cause him to think he may be a student, like is familiar with the target individual, and says, look, this kid's been graffitiing all over campus. This is what he's been graffitiing, and this is where he was doing it. Well, when the principal came in to work that day, before he even got that call, he had seen the graffiti. And so you've got all kinds of corroboration here, right? Despite the fact that we have no idea who the informant is, right? We look for things that they have said that turned out to be true, that bolster the credibility. He got the location of it, he knew the location of the graffiti, he knew the nature of it, what was on it. He seemed to indicate some familiarity with the student. The court looked at all those things and said, you're good to go, you're fine. So again, just sort of a training example. Permissible in scope, right. So obviously search, it's got to be reasonably related to the objectives and not excessively intrusive. We've kind of covered a lot of, the measures adopted reasonably related to the objectives, right? You can't search a place where something, might not be. And these quotes sort of go to that generally. That sort of general principle. I like the bottom quote. It's just a nice quote from the court. Parroting an example I think I gave early, saying, look, if you believe that the guy's in possession of a lawnmower, you don't get to search the upstairs bedroom, And just a couple of examples, TJ versus State. You've got a couple of girls, they're in a fight. One of them avows they're going to bring a knife to school the next day. The teacher gets wind of that and has a reasonable suspicion that student might be in possession of a weapon. Are they good to search? Yeah. The problem is they go into a tiny little inner container and they find narcotics. And the court says, obviously, no way. I really like this example, and I think it's like a 2-page case, right? State versus Taylor. And it's very similar to New Jersey versus TLO, right? The sort of the seminal case, which is a case involving teacher sees student smoking or something, has reasonable suspicion, conducts a search of her purse, uncovers the items. The court says that's fine. This is similar. Teacher sees student smoking and then asks him to remove his shoes, conducts a search of the shoes, and finds dope. And the court said, sorry. And when you read this case, you can almost feel how the court is just longing to uphold this, okay? Because at least me personally, I got the sense the court really believed this person had a subjective belief that the search would turn up evidence, but they don't articulate it, right? They don't explain that, okay? So here's what the court says, right? And they just go through a list of things that were not described, right? It's unclear from the record whether it is an infraction of the school rules to possess cigarettes on school property or only smoke cigarettes. Really important, right? If it's not an infraction, it's got to be a violation of the school rules of the law, right? Important to note that, right? Make a note of that. And in fairness to whoever the investigator was here, it's unclear whether it was his fault or just the attorney who was, the prosecutor who was doing it didn't elicit this information. But nonetheless, okay? It's unknown for Mr. Taylor whether he denied smoking or just possessing it. It's unknown whether any of the other students caught smoking in the restroom either admitted supplying the cigarettes to Mr. Taylor, the target, or possessed any. important, right? Why is that important? Well, because if there's information that tends to suggest that the target, the student, was the supplier, well, then it's more likely that he's going to be in possession of it, right? As opposed to just a recipient, right? It's unknown whether the other students reported that Mr. Taylor, the target, supplied the cigarettes that they were smoking. We talked about that. There's no testimony from the officer explaining that the students are routinely caught hiding cigarettes in their shoes. I don't know whether that was true or not, but just an example of, yeah, your experiences. If that's something that you see all the time, you've got to put that down, because the reasonable person steps into your shoes with your knowledge and experience. There's no testimony or evidence indicating whether the officer searched the remainder of his clothing, asked him to empty his pockets. Really important for a couple of reasons. First of all, you always should start with the least intrusive, right? You should be starting with a pat down or something like that, just in principle. But more importantly for our discussion, that's important because let's say that you've got suspicion, a strong suspicion that the student is in possession of these items, and you conduct a search of the other areas, right? It's not in his jacket, it's not in his pockets, well, then it's more likely that they're going to be, it increases the likelihood that they're going to be possessed in the remaining items, particularly the shoes. And if they had done that, then it would have been significant, and it might have worked out in this particular case. And then the court concludes by saying, given all the unknown facts, it's difficult to evaluate the reasonableness of their actions under the particular circumstance of this case, which just goes right to the heart of sort of the message that I've sort of been trying to communicate on this. And then they cannot be excessively intrusive, right? And I need to talk about state law here again real quick. So 1546.1c pertains to electronic devices. This is a messy statute, let me tell you. And the one thing that I can, without having any inside knowledge, but basically guarantee you, is that the drafters of this, I remember when this statute passed, did not have in mind school searches. And the language that they use and the way that they articulate it is problematic for schools. I know there was an attempt to amend it a few years back that failed. But in any event, basically, it just says, well, I'll just sum it up for you. Basically, it just says, look, in order to get consent to search, right, it has to be from the authorized possessor, right? Not the owner of the device, mind you, the authorized possessor, right? What is the authorized possessor? Well, that's defined in 1546b, which basically says the authorized possessor is, first of all, you have to actually be in possession of that. Well, the reason that causes problems for districts, and I've had this come up a few times now, is you've got student, right? You've got his cell phone. You need to search it. Student says pound sand. You're not getting in there. So what do? You call parent, right? Hey, is this your cell phone? Yeah. Well, the problem with this statute is that it prevents the parent then from giving consent that would allow you to get into that cell phone because they're not the authorized possessor, right? Which, if you start drawing other conclusions, you look at Chromebooks and things like that, it causes all kinds of problems. Now, the legislature saw these problems because they deal with it in subsection K of that code, I think. Situations where you've got maybe a police department lending out tough books to its, employees. Can they get them back? And they say, well, it doesn't apply to employees, right? But they don't mention students, right? And so it causes these types of problems. Here's what I recommend, okay, if you're in this situation and you're trying to get consent from the parent. It's kind of an end run around the statute, and I think it might tick the court off if you were in the real world. But in the school setting, I think, per the letter of the law, it's legitimate and it would be upheld. I think what you need to do if you're in that situation and you're seeking consent from the parent who is not on campus, right, with you, is you need to ask the parent to allow you to seize the device, right, to come in possession of it and in addition search it. Now you're the authorized possessor. You've got the, and maybe just for fine measure, ask them to revoke the permission of their child to possess the device, okay? That does it. Now you're the authorized possessor. Otherwise, it runs into problems here, okay? 49050 of the Cal Ed Code, don't ever do strip searches. Just don't. It just, and they define it very broadly there. When I'm talking to districts about as far as I recommend they go is if you've got information that student might be in possession of a weapon, ask them to lift up their shirt so that you can view the waistband, and no more. Beyond that, just stay away from it. I just have not found many cases where we're not getting hammered on that. So, yeah, so that's the definition. And that's the presentation. I know that was a lot, really, really, really fast. Let me end with two things. First of all, my email address is right there, okay? My phone number, 661-444-0340. That is this cell phone, right? It's on me all the time. And if you want to rap about search and seizure in schools, you got a question, give me a call. You know, as I tell the districts I represent, I'm always working, and I'd be delighted to talk to you about it. Yeah, with that, I will thank you.